very much the things that we talk about and what it's all about. So we first have to step back a little bit and talk about what is estate planning about. Estate planning is all about control and keeping control of your assets, keeping control of your body, and keeping control of your situation if you are, well, when you are hit with the extra expenses of growing old. I mean, this is a very young group of retirees. That's one of the good things about the union program, is that you do get to retire younger while you still are able to be active. But estate planning is all about control. One of my instructors years ago said that estate planning is all about who gets what, where, and how. But really, what it's about is signature. Nowadays, if you want to control anything you own, or say, yes, a doctor can do something to you or for you, you sign your name. Estate planning first deals with what happens if you can't sign your name. If you don't make any sort of provision for it, our dear government, our state government has provided a way for your name to get signed for you. Now, if it is because you have died, we call it probate. And if you have just a basic will, or if you have nothing at all, and you die, and you own anything significant, you go through a process at the probate court. The probate court will appoint someone to handle your assets and distribute your assets out to those people who are supposed to get it. If it is because you are alive and cannot sign your name, you cannot manage your own affairs, we call it conservatorship. In a conservatorship, someone is appointed, you lose the authority to sign, to control anything, someone else does it all for you. The biggest problems are that we can get impaired to where, yes, we can't balance our checkbook anymore, but we know where we want to live, who we want to live with, what we want to provide or not give to our family. And the court doesn't know that if you're stuck in a conservatorship situation. So from my point of view, both conservatorship and probate are dirty words. They're dirty words not only because it's the court taking over your life, not only because all of your affairs now become public. So what you own, what you don't own, how many kids you have, all that is in front of the public if you're stuck in a conservatorship or a probate. The other problem with them is that they're both very, very expensive. Typical starting fee just to get a conservatorship rolling is $5,000 out of your family's savings. And it goes on, and there are costs every single year. A probate is also very, very expensive. Typically, most people lose between 3 and 6% of their assets if they have to go through probate. That's money that doesn't go to your family. Never mind death taxes, this is the cost of just having the court supervise. So, in trying to find a way to keep the court out of our business, you have to take the step and do active estate planning. Now, we have certain tools in California that are our core tools. The tool that most people hear about anytime they go to the hospital or the doctor is their advance directive, their healthcare power of attorney, which gives someone else the power to make medical decisions for you, if you're not able to. And from a doctor's point of view, the moment you have a painkiller, you can't make your own decisions, can you? You can't really be informed from their point of view. If they choose that's a perspective, they want to adopt right then. Now, the hospitals are required, after a set of bills introduced by the probate section, to make access, give you access to a healthcare power of attorney form. The trouble with that form, as opposed to an attorney-drafted form, is that it doesn't give enough detail. If you have a spouse, you have children maybe from another marriage, every person is going to think that you want a different thing. Having clear directions in your healthcare power of attorney is the best way to avoid conflict between them. We also use financial powers of attorney, and we also use both revocable and irrevocable trusts. All those to maintain control of your assets, protect them from the expenses of the state being in your affairs, and perhaps even qualify you for extra benefits that you wouldn't be entitled to otherwise. We talk about the 7 sins as to estate planning. The first one is dealing with the healthcare concerns. How many people in the room here have a healthcare power of attorney right now? You know, that is the largest number that I've seen these past 3 years that I've been here. That's awesome. Unfortunately, that's still only about 15% of the people in the room. How many of you have a son or daughter who is less than 25? Now, for them, healthcare decisions are also important. Until they were 18, you can make your medical decisions for them. Right now, if they go to the hospital, you can't say a word. The doctors will not be listening to you. The doctors under the HIPAA laws cannot tell you what their situation is. Their privacy prevails. So even if you aren't willing to take the time to do a healthcare power of attorney for yourself that gives good directions for those who are close to you so they know what you want, they don't feel guilty about it, take the time to get your kid in along with you to do a healthcare power of attorney for them. When we do planning for our clients, for union members specifically, if you have children who are 18 to 22, if we're doing your plan, we'll do their healthcare power of attorney and their financial power of attorney without an extra charge. It is just that important. The second mistake that people make is that they fail to plan to control their finances, to control their property when they're incapacitated. The number of people who do wills nowadays, writing them out by hand and using software, using services, has grown. And that's wonderful. The trouble is that a will by itself does not give any directions for what's to happen if you cannot act for yourself. A durable power of attorney can provide for that. Now, when I started practice, my first experience in the law firm over 25 years ago, our power of attorney was 2 pages long. And half of the second page was for signature and the notary. What's happened in the decades since then, is that more and more institutions require a specific authorization that says that your agent can do this, can do that. Yes, they can talk to the union pension administrator about your pension. They can talk to your health insurance company. They can talk to your bank. If you have a mutual fund, they can talk to the people who handle your investments. If you have a piece of real estate, they can deal with tax issues for your real estate. If you rent out if you've got a 2-on-1 and you rent out the back room, then they can deal with landlord-tenant matters. Every single thing that you do in your life should be in that power of attorney. So the standard form ones, they give you comfort so maybe you can sleep at night, but they shouldn't because they don't give enough details. Now, another alternative as to your property, besides the power of attorney, is to use that combined with a revocable living trust. And a power of attorney is a wonderful, powerful tool, except people have to accept it. Now, you take your power of attorney to the bank. It's not their form. They will send it to their legal department. If it's done right, 1 to 2 weeks, 3 weeks later, they say, yes, you can act under the power of attorney. But that is slow. And your family may need to access your bank account before that. A much better tool is the living trust. And we'll talk about that more a little later. but the living trust holds your assets while you're alive. You're in full control of your assets. You're the founder of the trust, you're the chief executive officer of the trust, the trustee, and you're the shareholder, you're the beneficiary during your lifetime. Because it already holds the assets, and it has built into its documents a chain of command, being able to take over the bank account, deal with it, deal with the house, that's much quicker, much smoother, and you get a lot less pushback. The next great mistake, and I apologize if I'm going very quickly, these are all important things for us to touch on, but this is really an hour-long presentation, and I've only got 20 minutes with you, so I apologize. I'll be staying around afterwards and answering any questions that you might have. Sin number 3 is no property transfer strategy. Now, you need to have things set up so that when you pass, the things that you want to have happen. Do you want your house to be kept in the family? Do you have a child living with you that you want to be able to live there for a year, but then need to get out on their own? You need to set out who gets the stuff that has meaning. More people have fought over a set of candlesticks than you can imagine. So laying out those specific things that are emotionally important to your family, it's so important to be put in the documents. Just saying it orally, your kids are going to argue as to whether you said it or not. If it's in writing, it's hard for them to argue about. Who gets your mother's engagement ring? Who gets your grandfather's wedding ring or his Masonic order ring? Those things are incredibly important. Most people think about estate planning and doing trusts as being all about the money. It's not. It's all about the family. It's about keeping your family from fighting with itself. Because the inheritance of family fighting and conflict is not what you want to pass on. And without good documents, it becomes much more likely. We already talked a little bit about children and dealing with them, and that's fine as what the kids own. But a bigger issue is you've worked your entire life to build up assets for your family. How fast can your kids spend it? And how much damage can they do to themselves and their future by spending it? Back 50 years ago, when we set up documents, most trusts, and still a lot of attorneys do this, are what we call dump-out trusts. And those are okay in rare circumstances, when the kids are really together and they've got really trustworthy, stable marriages, they're in low-risk jobs. Oh, does anybody have kids like that? The better approach is to set things up so that the kid's inheritance is protected. Sometimes the most important thing is to protect it from their spouse and from divorce. Maybe for just ordinary things you want a certain amount to be available to them each year, but to take out a lump sum, they need their siblings' permission, or another uncle's permission, or another outsider's permission. You don't want your kids to be able to easily put your daughter or son-in-law's name on the account. And, it's hard to keep people from doing it. Using a trust with inheritance protection in it is the best way to do that. And of course, spouses are one risk, car accidents are another. You know what things your kids do and don't do. Or think more what your friends' kids do or don't do. We always look at our own kids in a good light. Sin number 5 is the sin of not taking into account that you've got a blended family. You've got a second spouse, you got kids perhaps from a first marriage. How do you do things in a fair way? Because most people, with the way that they set up their plans, or if they don't plan at all, if they die before their spouse gets everything, their kids from a prior marriage are left out in the cold. By using proper trust planning, we can set things so that the surviving spouse, has what they need, but not more than they need. And whatever is left is going to be protected for the kids. You can also provide that part of the assets are allocated and set aside for the kids right from day one. And that's another approach that many people choose. The number of widows who are hit on and seduced by gold diggers when they're older is amazing. Yes, the 80-year-olds that come into my office with 60-year-old broke boyfriends, that's not what it's about at all. But you see that, they don't even have to be handsome. They just have to be charming and attentive. And you worry about that. Those are the cases where you send that spouse out of the room sometimes, or you try to talk realistically about the kids. Also, if any of you come in and your kids are with you, for part of our conversation, we're going to kick the kids out of the room. I want to know that they're not twisting your arm. And even more so, if you bring your parents in to see me, I'm going to kick you out of the room. Because I want to hear what they want. As an attorney, your focus is on your client. Yes, we take into account the whole family, but we need to know what our client wants, and we customize our documents and what we put together for what each family needs. So the solution to those sorts of situations is what we call trusting your spouse, having the assets provided for them in a trust. Now, one thing that we do very commonly is we'll set up a trust for a spouse with your half of the assets, and this is even on a first marriage. And we'll put into the trust a provision, if you want us to, that says that if I die first, my half of the assets are put aside, you have access to them for what you need, but if you remarry, you must have a premarital agreement where your new spouse says, I will not make a claim against that other half, your deceased spouse's share of the trust. And if you don't get that premarital agreement, it has a penalty in the document. And the penalty is that you may have access to the earnings from that money, but you can't take the principal. And that way it's protected for the kids. Now, you would think, oh, that's really harsh. But what it does is it lets you say to your new spouse, your new significant other, I set up this darn arrangement with my ex-spouse who's in the ground now, and I've got to get a premarital with you. It isn't that I don't trust you. It's that my dead spouse didn't trust me. Well, and it would have been the other way around if they survived. So having that sort of provision is very, very important. Sin number 6 is perhaps the biggest sin in some ways. For the last several hundred years, estate planning attorneys focus primarily on what happens if our client dies. But we don't die as early as we used to. When the Social Security retirement age was set at 65, copying Germany set the retirement age at that because people only lived an average of a year and a half past 65. Nowadays, the chances are 1 in 3 that each of us, if we reach 65, that after that we will need long-term care of some sort for some duration. That's a devastating number. We will need care in our homes. We may end up needing assisted living. We end up needing nursing home care. You have to make a balance, and that's part of what we do with our clients when we talk about this, is how much do I want to pay for my care myself? How much do I want to tap government entitlements to pay for my care? And in doing that, preserve my nest egg that I built up all these years for my kids or my grandkids, because they can't afford a down payment on a house very well. Or they're struggling with their credit cards. I want to preserve that nest egg, if that's important to you. Then planning for your own older age and needs is really important. One benefit that very few people know about, for any of you that served in the military during wartime, if your assets are arranged the correct way with the right type of trusts, or if you're actually completely broke, there are veterans benefits that for a wartime vet with a living spouse can pay a little over $2,000 a month for in-home care or towards living in an assisted living. Very, very powerful benefit. But you need to know about it and be ready to seek it out if that's something that you see coming in your future. And we also have state and federal entitlements as to nursing home care as well, but you have to arrange your assets the right way, or you have to spend it down until you have next to nothing. The final sin I'm going to talk about is failure to update. A double handful of you show that you have a plan or at least a healthcare power of attorney already. It is incredibly important that you update your documents. Not only are you facing different things in your life, your kids are getting older, your property has changed, your income has changed. The documents need to be updated for that reason alone. But your needs are different. You need to have provisions in there that would allow someone to shift your assets to protect you against long-term care needs. You need to have provisions in there that deal more with incapacity and what standard you want. Most trusts that you have, if you have a trust now, I would give you a 99% chance that it says that if you're incapacitated, you lose all ability to control your assets. And it defines incapacity that your doctor or two doctors have said that you're not able to manage your own financial affairs. The language that's used is too broad. You still can decide where you want to live, who you want to live with, and it shouldn't turn over to your kids or to the state the ability to give you an allowance on how much you should be spending each week, unless you're spending so much that you're putting yourself in danger. It's your own money. So updating your documents to provide for that is incredibly important. We've seen trusts come in. Let me introduce Damien Stills in the back. He's been with me in my office for 10 years now. Damien, what's the shortest trust you've seen?
Shortest, 2 pages.
2 pages. And that 2 pages has to provide for what's going to happen to your family, what assets can be managed, and how you should be maintained if you're incapacitated. It can't do that. A modern trust with the provisions that should be in there can't be less than 50. You just can't cram it in and cover the things you need to cover. Now, how am I for time? About, okay, so I think it's really fast. I'm sorry. Thank you. Now, we work with a lot of union members. We don't charge union members for our initial meeting with them. We also, for those of you that own homes, when you purchased your home, you got a copy of your deed. Now, it's not like a pink slip that somebody else having your deed means that they got your house. But it's still an important document, and in estate planning, we need to have that. For union members, we don't charge for retrieving a copy of their deed from the county records so that we can work with it in your estate planning. As I said, we don't charge for kids' documents along with yours, as far as a healthcare power or financial power for them. you get when you're not having to schedule to go to work. As my father-in-law says, he's so busy now that he's retired, he doesn't know how he had time to work. And I wish that kind of happiness for all of you. So take the time as soon as you can, come in, do your estate planning. For those of you who aren't local, if you need a recommendation who's closer to you, we can certainly help you out that way. But for those of you who are within St. Anne County, for the first 10 people who set up an appointment to come in and see me, just if you stayed awake and paid attention through my whole presentation, I feel you deserve a Starbucks card. So I got 10 Starbucks